I welcome you all for today's webinar on public interest litigation and judicial activism in India. And we have invited two experts related to PIL and judicial activism field. Mr. Anubhav Kumar, he is practicing advocate at Supreme Court of India, and Mr. Gautam Kumar, faculty in law, UPSC School, Dehradun, Uttarakhand. The public interest litigation and judicial activism are closely related legal concepts. Public interest litigation emerged as a direct result of judicial activism in India. Public interest litigation and judicial activism have been instrumental in promoting social justice and protecting human rights in India. The term of public interest litigation allows individuals or groups to approach the courts on behalf of others, particularly those who are marginalized or unable to represent themselves. The factors contributed for the growth of public interest litigation in India are, firstly, the proactive role of the judiciary in addressing social justice issues beyond traditional litigation, and the courts have taken the cognizance of matters involving public interest, thereby encouraging the citizens to approach them directly. Secondly, irrespective of the financial status of disadvantaged groups, public interest litigation was emerged as a platform to seek justice. Thirdly, non-government organizations often serve as facilitators in public interest litigation cases, bringing public attention to pressing issues. Fourthly, legal framework governing public interest litigation has facilitated the filing of public interest litigations by concerned citizens, activists, and lawyers on behalf of the affected parties. As far as the constitutional provisions that support public interest litigation in India is concerned, we have Article 32 and Article 226 of the Constitution of India. Any Indian citizen or organization can move the court for a public interest by filing a petition in the Supreme Court under Article 32 and in the High Courts under Article 226. Any citizen can file a public case by filing a petition under Section 133 of the Criminal Procedure Code in the Court of Magistrate. Article 32 allows individuals to directly file a petition before the Supreme Court for protection of their fundamental rights. It allows the court to issue writs, including the writs of habeas corpus, mandamus, prohibition, quo warranto, and certiorari for the protection of these rights. Article 226 provides the High Courts with the power to issue writs for the enforcement of fundamental rights within their respective jurisdictions. This includes the authority to entertain public interest litigation petitions and issue directions for the protection of public interest. Some of the matters which are entertained under public interest litigation are bonded labor matters, environmental pollution and disturbance of ecological balance, neglected children, non-payment of minimum wages to workers and exploitation of casual workers, atrocities on women, food adulteration, maintenance of heritage and culture. On an average, Supreme Court receives over 25,000 public interest litigations every year. Between 1985 and 2000, the Supreme Court has received over 9 lakh public interest litigation petitions. As far as the various fields in India include civil service exam question papers, price control of life-saving drugs, state-wise grant of minority status, stray dogs welfare in Delhi, challenging the appointment of the Central Vigilance Commissioner, PM Cares Fund, management of man-animal conflict in Uttarakhand, protecting the rights of sanitation workers during COVID-19, strengthening the institution of Lokayukta, Delhi, petition on electrocution by live wires, extension of audit jurisdiction of Comptroller and Auditor General of India to Noida, public interest litigation to file the bid of Government of Andhra Pradesh to export logs of red sandalwood, PIL bill on corruption in the management of defense lands, illegal mining in the state of Odisha, irregularities in allocation of coal blocks for captive mining. The public interest litigation helped the government to take the necessary actions in response to environmental crises such as 1984 Bhopal gas tragedy and 2015 Chennai floods. The judicial activism refers to proactive role of the judiciary in interpreting and applying the law to address social issues, fill legislation gaps, and protect citizen rights. The judicial activism is rooted in the belief that the judiciary should go beyond its traditional role of merely interpreting the laws and take an active role in shaping the social policy. After independence, the judicial activism was almost silent for the first decade. During this period, that is the first decade after independence, the executive and the legislative organs of the government actively dominated and intervened in the working of the judiciary. It takes shape in 1970s and 1980s, a period marked by political turbulence and challenges to civil liberties. The emergency declared by then Prime Minister Indira Gandhi led to widespread abuse of power and suppression of fundamental rights. The judiciary's passive stance during this period, particularly in cases like ADM Jabalpur versus Shokan Shukla in 1976, where the Supreme Court upheld the suspension of habeas corpus led to a crisis of credibility. The Supreme Court, under the leadership of Chief Justice like P.N. Bhagavati and V.R. Krishnaiyer, started interpreting the Constitution in a manner that expanded the scope of fundamental rights and increased judicial oversight over the actions of the executive and the legislature. Several methods of judicial activism are used in India as review by the courts, public interest litigation, interpretation of the Constitution, access to international statutes for the petition of constitutional rights, and the upper court have supervisory authority over the lower courts. We are towards at the end of my introductory remarks. In India's legal system, judiciary activism and PIL have played a vital role in protecting the public rights, promotion of social justice, and the accountability of government and public authorities. Judicial activism provides the ideological foundation for PILs, while PILs offer a practical mechanism for the judiciary to exercise its activist role. The concept of judicial activism has both positives and negatives. If the judiciary intervenes too much in the working of the other organs of the government and tries to overreach the constitutional powers, then this concept of judicial activism loses its importance and essence. PIL's actions may sometimes give rise to the problem of competing rights and also lead to overburdening of courts with foolish PILs by parties with vested interest. PIL matters concerning the exploited and disadvantaged groups are pending for many years. However, PILs have played a crucial role in protecting the environment and natural resources and preserving the forest and wildlife, safeguarding the rights of indigenous communities. With this, I stop my presentation by highlighting judicial activism and PIL can continue to serve as vital instruments for social change when the judiciary ensures that the interventions are guided by the larger public interest and to protect the rights of marginalized sections of the society. The clear-cut criteria for a filing and admitting PILs should be developed to prevent its misuse by conducting public awareness campaigns to educate the citizens about the role and significance of PILs to encourage their more appropriate use.